What's up, guys? Brian Fell, Fell Law Group PLLC, back with another edition of the Florida Law Weekly Case Update. I got 5 cases for you this week, so let's get right to it. The first one is Padilla versus Pickett. It's out of the 4th DCA. It's a domestic violence case, and I actually somewhat disagree with the holding here. So this was a case filed by, it seems like, a father on behalf of his daughter, alleging that the mother committed domestic violence against the child. And the court actually dismissed the domestic violence petition, saying that the sole incident alleged was essentially too far removed, too far in the past, too stale to constitute a domestic violence injunction. And I know that's the law, and I've seen that before in other cases, but I disagree with that, because the statute itself defines domestic violence as including any battery. It doesn't have any time frame on it. It doesn't have any statute of limitations or anything like that. What the courts have done is essentially written into the statute a vague statute of limitations, sort of, that if it's battery but it's too far in the past, it doesn't count. I don't really like that, but that's what the case law says, and the 4th DCA affirmed the dismissal of this case, saying, no, if you're only alleging one incident of physical violence, if it's too far in the past, too stale, that doesn't count, and that's legally insufficient to even move forward on a hearing on a domestic violence case. So that's something to keep in mind. I disagree with that. Maybe the law will change in the future. Next case is Deasy versus Deasy. It's again out of the 4th DCA. This is a dissolution of marriage case. It had a multitude of issues. The first one was the trial court's failure to do the basics in equitable distribution: identify, value, and distribute the marital assets. Apparently the trial court did not do that. That's something that all trial courts have to do in every case involving equitable distribution. You need findings that the trial court identified the marital assets and liabilities, valued the significant ones, and distributed them and designated which party is going to receive them. The other thing that was interesting about this one was it involved the wife claiming that the husband forging her signature on the party's tax return made the tax liability a non-marital liability because it was incurred through forgery. Actually, the 4th DCA said, no, that is not what the legislature meant when they said that a liability could be deemed non-marital if someone forges your signature. It's not like a mortgage or a note payable or a loan or something like that, where somebody literally just forges your signature. For this one, for taxes, the underlying liability is non-payment of taxes on the income that you or your husband received. So the incurrence of the liability was not because somebody forged the signature. It was because you didn't pay your taxes. Now, I think maybe the wife may have a case that, well, maybe not the original liability for failure to pay the taxes, but maybe the interest and penalties. Well, the court rejected that and said, no, you're not going to be able to claim that that's a non-marital liability because your husband forged your signature on the tax return. So be careful about that. The other thing that was interesting in this one, the husband sold a Mercedes van for $1,000 when it was really worth $30,000, and the court said that should have been treated as marital waste. A lot of times we think of dissipation as sex, drugs, and rock and roll, things like that one party spends money on those kind of things, but it could also be considered when a spouse sells an asset for far lower than it's really worth. That's also could be dissipation, so keep that in mind. The court also reversed because there was failure of specific findings on the wife's reasonable monthly need for alimony, her expenses. The court has to make written findings of the wife's or the recipient spouse's actual monthly expenses for alimony purposes. So if the court doesn't do that, it gets reversed. And then the court also forgot to include or account for the wife's potential income from her assets that she was going to receive in equitable distribution. Remember, for alimony purposes, the income that the recipient spouse receives from its assets, from interest and things like that, earnings on the assets, that can be considered to reduce the recipient spouse's need for alimony. So the trial court has to take that into consideration. All right, the next one is Reed versus Reed. This is a 4th DCA case, and this was a dismissal for want of prosecution, that FWOP. Basically the trial court said, right, there was no record activity in the last 10 months before the notice of intent to dismiss for want of prosecution was issued by the court, and there was no record activity from the petitioner for the last 60 days after the notice was issued. The 4th DCA reversed because record activity, it does not only include record activity by the petitioner, it also includes record activity by the respondent, and it includes any record activity. So it's basically a black and white zeros and ones inquiry where the court just has to see, was there any record activity in either the 60 days after the court issues the notice of intent to dismiss. If there was any record activity, which here there was, it was from the respondent, then the case cannot be dismissed for want of prosecution. So that was a reversal. The next one is a landlord-tenant case, a commercial landlord-tenant case, and it's 5051 Northwest 37th Avenue Corp versus IES Sales and Service LLC. This one was sort of a harsh result in my opinion, but it is the law. So in a commercial landlord-tenant dispute, if there's going to be any payments of the rent, they have to be made into the court registry. If the court orders that payments must go into the court registry, they have to be made timely. And so in this case, the court issued an oral ruling basically on it was April 26th or something like that. And then and on April 26th, the court said you have to deposit the rent into the court registry by May 1st. But the court did not enter its actual written order until a week later. And then 7 days after the written order was when the tenant actually paid the rent into the court registry. And the appellate court said, no, that's too late. Trial court has no discretion, must enter a default judgment in favor of the landlord if the tenant fails to timely deposit the rent. The fact that the court issued its written order later didn't matter. The fact that the statute said that the court could have some discretion to extend the deadline did not matter, because that would be applied retroactively after the court actually said that May 1st was the date that you have to deposit the rent. The court could not then afterwards say, oh, I'm giving you a retroactive extension of time. No, it's a per se rule that if the tenant fails to timely deposit in the court registry, then the landlord gets an automatic default judgment for possession. Last case I have is out of the 5th DCA, and this was interesting. This is a 57105 case, and it involves contractors. And I did some of this work in the past, but basically, if you have a case where you represent a general contractor who is not licensed, an unlicensed general contractor, do not bring an action for breach of contract to try to enforce that contract, because you could get hit with 57105 fees. That's exactly what happened in this case. Someone was representing a contractor. They did not have a license. They performed work. They got a construction lien on the property, and they said, hey, let's sue to enforce the construction lien. Let's file an action for breach of contract. Well, it turns out they were not licensed, and the opposing lawyer sent the 57105 notice in motion saying, hey, you guys know this person was not a licensed contractor. You cannot enforce that contract. Well, they proceeded anyway. They tried to get a little cutesy with their language because the contractor subsequently became licensed. Anyway, the trial court denied the 57105 motion. The appellate court actually reversed and said, no, this is a 57105 territory. The lawyer knew that his client was not licensed, and he pursued a breach of contract action regardless. So that lawyer is now responsible to pay for all the reasonable attorney's fees and costs incurred by the other party. So the other party may get a huge windfall here if they actually had work performed for them by an unlicensed contractor, yes. They may not even have to pay for the work, and they may get all of their attorney's fees paid for. So that's a pretty big windfall. So just be careful if you represent contractors. All right, guys, that's it for this week. Take care. Hope you guys have a good week. Bye.